right to grow his own marijuana. Nothing in the text of the Florida Constitution grants patients such as Mr. Redner a constitutional right to cultivate and process medical marijuana. Under Article 10, only medical marijuana treatment centers, as they're defined in B5 of Article 10, Section 29, are given that state law immunity for the activities of cultivation and processing.
I think as I understood Judge Geaver's analysis that the appellee advocates for here is that if you look at the statutory definition of statutory definition of marijuana, which is incorporated into the Constitution, it includes the plant whether growing or not. So the argument goes, you have the right to medical use of marijuana, which is a plant growing or not. So you have the right to possess a growing plant. How do you respond to that?
Your Honor, you're exactly right. That's what the appellee's argument was below, and that's what Judge Geaver's adopted. And what they're doing there is, it's the wrong way to read the law. They are taking one provision, the medical use definition and the incorporated marijuana definition in the statute. They're taking that one provision and they are pulling it out of the whole act, reading it in isolation to turn the Medical Marijuana Amendment 2 on its head and ignore the rest of it that says that it's the MMTCs that have that immunity under state law for cultivation and processing. Patients don't have the immunity for that activity, nor do the physicians. They can't cultivate and process, or the caregivers. This amendment is not about what marijuana is or is not. It's an amendment that granted state law immunity for certain activities, and they set out 4 categories of individuals or businesses, and they say exactly what activities that those 4 categories have the state law immunity for. So you don't read the law by pulling a provision out in isolation, ignore everything else, and say, voila, I found this loophole that even the folks that drafted the amendment say is not in the text, and that's the United for Care committee.
Why should we concern ourselves with what the drafters thought?
You should not concern yourself with what they intended or didn't intend by drafting it, but we did introduce from their website what they said about it to the voters in the ballot title and summary and on their frequently asked question on their website. And the relevance of that is that lots of people looked at the text, which is what should guide you. All these people looked at the text and nobody saw a right to grow your own marijuana. That's not what the purpose of this was for. It was to give a medical use immunity for certain activities to patients, not including cultivation and growing. So on their website, and the reason we called it out is they said, lots of people are asking about this, is they look at the text and nobody was debating whether or not in the text there was actually this right. They were saying it's not there. Everybody who looks at it says it's not there. Why is home growing not mentioned in the ballot language? This is on page 533 of the record. And United for Care's answer was, the amendment does not allow patients to grow their own marijuana at home. While many supporters and patients expressed their desire to see this provision included in the law, United for Care left home grow out of the amendment in order to create a tightly regulated and controlled system that's best for the state of Florida. Again, as appellate judges, you shouldn't look at that for what they intended. You should look at it for what text did they actually arrive at. And the text that they arrived at does not include immunity for that. And Judge Liz Rice, a highly respected 13th Circuit judge that first had this case before it was transferred to Tallahassee, she had to look at the text and she said there is no constitutional right to home grow. And the reason she had to make that ruling in transferring it was because the appellee below was resisting and opposing our motion to transfer it. And so he alleged that there had been an unlawful infringement of a constitutional right. And so Judge Liz Rice looked at it, said there is no right to home grow in this text, just like the folks who wrote it said. And so she transferred it. Judge Geavers gave no deference to Judge Rice's ruling and instead adopted this narrow-minded reading of just pulling out one provision and using that definition to completely ignore the whole structure of this. And we're required to read related provisions of the law in pari materia. You read them all together to understand the meaning of the text, and that's also called the whole act canon, that we read the whole act rather than pulling out one provision and ignoring other related parts.
Now, I can't find it right now, but somewhere in Judge Geaver's ruling, she mentioned that his right to grow and keep and juice and those sorts of things had to be done in a secure way. But in her order component, I don't think she included any terms as to what those security measures were. Am I remembering the order correctly and missing something?
Yes, Your Honor, you've definitely studied the record. Earlier in the injunction hearing, when this came up, I talked about the fact that there are several states that do allow for home growing. And what they have in common that they don't have in common in Florida is they all have actual text in their statute or constitution that says people will be able to engage in home growing, and then they put all these conditions on it, such as in the state of Maine, you can only have a certain number of plants, they have to be behind a fence that's a certain height, or indoors, they have to be secured in a certain way, locked up, and you can't see the plants from off the person's property. We don't have any of those conditions in Florida, and so Judge Geavers denied their request for the injunction, but said, I do think you have a constitutional right. I found it here. And so we're going to come back at a final hearing, and I want to hear more testimony. I want to take testimony on what the conditions should be. And I argued at that final judgment hearing that this is taking on the character of a legislative committee hearing, where you're taking testimony that in a state like Maine, they would have taken and said, we're going to study this and we're going to put these restrictions on it. That's not the role of the court. And so she backed off and did not put any restrictions in there. I think she just said whatever the doctor says he should be able to do, he should be able to do. And it has changed throughout this. Early on, I think he wanted 40 plants to grow. His expert said, one of his experts that actually has engaged in juicing marijuana, I think he used 3 to 5 pounds of marijuana a day that he juiced, but now it's not defined.
As we stand right now, if this order was affirmed, there would be no security restrictions on how the plaintiff here, or I guess it's either plaintiff or the defendant, how the appellee here or any other person who had a similar prescription would keep their plants, correct?
I think that's correct, Your Honor.
And how is that different in the way that the medical marijuana treatment centers are required to keep their supplies?
The MMTCs, I think, are subject to some significant restrictions. They track the plants. There's high levels of security. All those things, I think they're going to be addressed in a different case, but there are regulations and statutes that govern all those restrictions. There's none of that in Judge Geavers' order, and certainly not in the text of any provision of the Constitution or statute.
Okay.
The amendment adopts the definition of cannabis used in Florida Statute 893.02, but the amendment did not reference that same statute to define cultivate or cultivating. Do you think there's any significance to that? That statute 893.025 does contain a definition for cultivating. Do you see any significance to the fact that the amendment doesn't refer to that definition?
I don't know if that was, I don't see that in the text that necessarily there's any special significance to it. I would just go back to the medical use definition, only providing immunity for patients for medical use of medical marijuana that they purchase from an MMTC. So obviously, you don't get the immunity for going and purchasing plants in Colorado or elsewhere and bringing them back. It has to be medical marijuana processed and purchased from the MMTC, not even from your doctor. So I don't know if there is any particular significance to the way that part was drafted, but certainly there's no right to home grow in the text of our amendment. Unless you have other questions, I'll reserve.
Let me ask you, go back to the security question. If I read the constitutional language that prescribes the duties of the department correctly, it gives the department the authority to adopt procedures, et cetera, for the treatment centers dealing with security. am I missing a similar provision relating to the patients?
I think it's not there. So I think you haven't missed anything. It's just, it's not in the text for patients to be able to cultivate and process.
And it would seem
And the
like
same with
then-
the physicians.
Right, it would seem like then if, without authority, if patients are allowed to grow it in their backyard, there would be no authority for the department to regulate how it's kept secure, how it's tracked, any of that, would there be?
Correct. There would not be, to my knowledge. Thank you.
May it please the court. I'm Luke Moreau. I have the privilege of representing Joe Redner as the appellee in this action. And let me begin by addressing the issues brought up by my colleague, and specifically in reverse order, the questions that were just brought up by the court. The department has the absolute authority to implement regulations that enforce and protect this section of the Constitution. All of these missing links that you seem to have identified are not because of some lack on the part of Mr. Redner to understand what his rights are. They've all emanated from the fact that the department, to this day, has never adopted even one regulation, the most important regulation, setting the amount. If they were to do that in accordance with the consistent provisions of this constitutional amendment, all those issues would be solved. They have the absolute duty to do that, not only just the right, but the duty to do that. They could adopt regulations consistent with this section that would address security, safety, all of those things. And I think what Judge Gievers observed...
Where do you see that? I guess I see that for the treatment centers, but I don't see that for, if you're right, if patients have the constitutional right to grow their own marijuana.
It's in subsection D where it says duties of the department. And this is the overarching consideration. It says the department shall issue reasonable regulations necessary for the implementation and enforcement of this section. The purpose of the regulations is to ensure the availability and safe use of medical marijuana by qualifying patients. It's the duty of the department to promulgate regulations in a timely fashion. That's their duty.
So if the department were to, if you're right, patients have a constitutional right to grow their own marijuana in their backyard.
Yes.
The department then, under that language you read us, would adopt security regulations.
Yes.
And if one of the regulations they adopted was that in order to grow it, you must do so in a locked room with access only available to certain people.
That would be consistent with this section. It would be ensuring the available and safe use of marijuana without, as the department wants you to interpret, destroying or negating the ability of a qualified patient for his medical use to possess a growing plant. The interpretation they want you to adopt does violence to a complete other section. So when I listen to my colleague argue about imperi materia and that we're selecting portions of this, that's exactly what they're doing. They're trying to urge that the use of the word cultivate in one section automatically invalidates or renders nugatory those provisions of the amendment that provide that a qualifying patient under that very important definition that was incorporated. And I think we cited the Benjamin case where they dealt with the adverse medical incidents, and I know we cited it many times in our brief. The Supreme Court basically said that by referencing another statute, that makes that definition part of this constitutional amendment. So by referencing 893.02 sub 3, that makes that definition of marijuana, which a qualifying patient can use and possess, just as important as the provision that allows medical marijuana treatment centers to cultivate.
I guess what troubles me about your argument that Judge Gievers accepted was this constitutional provision, if you read it from start to finish, has a very complex system set up that seems to contemplate that the these monopolies that have this business are going to be where you get your marijuana. And if in reality everyone can grow marijuana in their backyard, it seems like most of this constitutional amendment was a waste of time, energy, and effort.
I will respectfully disagree with that, because what the theory is that the medical marijuana treatment center, and I think this is even in the ballot summary. You have patients that have these debilitating conditions can use medical marijuana. That's how it begins, or at least I'm paraphrasing how it begins. Then it talks about the medical marijuana treatment centers. The immunities given to patients and caregivers, that's one set, doctors, and medical marijuana treatment centers, those are different immunities. They all have to be read in harmony. They can be read in harmony. I think the constitutional construction cases say if you can read these in harmony, then you have to do that.
But it seems to me that the overriding public policy is that the medical marijuana, medical use of marijuana by a qualifying patient or caregiver in compliance with this section.
Correct.
And that to me seems to be what drags all of these provisions together, that says that for people who, and as you say, certain people are doing different things, and the treatment centers are the ones that are cultivating and processing it.
Right.
What you want is your client to be able to cultivate and process it
Well,
in a
it goes
manner
a-
that he deems most appropriate for him, or his
I
doctor
think
does.
this is a little bit of the disconnect here, because what this does, and again, this violates the constitutional rights, because there is no marijuana available under the way that the legislature and the department have implemented this. You can have products containing marijuana, and what medical marijuana treatment centers can provide under the definition, it says marijuana, products containing marijuana. But when you get to 381-986, 1J, it says, no, you can't have the flower, you can't have the plant. So what at least in this amendment says you can have marijuana, which would be a 1, as the trial court observed, that means it's a 0. So she left it to the doctor, not because that was what she had to do. That was the alternative, because the department has not adopted those regulations that would be consistent. And I would agree with you.
But is that our case, or is that some other case, whether the regulations they've adopted are too restrictive on the type of marijuana that can be sold and consumed?
We have that in a table. It only shows what you can't have. So what was observed by the trial court was that the department has not done its constitutional duty by even beginning with something as basic as an amount. Let me address.
I'm not following how that matters. So they said an amount. How does that create a constitutional right to grow, process, and use marijuana from your backyard?
All
I'm
of the
not following.
cases say that you begin with the plain language of the amendment.
And that's where I'm struggling, because the plain language to me seems to suggest that the people, when they adopted this, said, here's how it's going to be structured, that we have these medical marijuana treatment centers, and they're the ones that do these activities. The amendment did not say that the qualifying patients can do those things, and certainly from a constitutional theory perspective, it's a grant of authority, right? And that authority is given to medical marijuana treatment centers, but I'm struggling to see where that authority is
The
granted to
same authority is
individuals.
given to the qualifying patient to possess a growing plant. You cannot render nugatory. The word cultivate, as Your Honor identified, that's not incorporated here. It's undefined in the amendment. What is defined in the amendment is marijuana. It couldn't be any more precise. It takes the criminal statute with a specific statutory number and even the year. There is no question of what a qualifying patient has the right to use and possess, a growing plant. And what the department is urging is that we...
Well, where does it say that? Maybe I'm missing it, the only one that I'm missing it, but I'm not seeing where this constitutional language says
Let me
that.
just, I'll take you through
Take
the
me through it,
analysis.
yeah.
The very first statement of public policy is that the medical use, that's a defined term, of marijuana, that's a defined term, by a qualifying patient or caregiver in compliance with this section is not subject to criminal or civil liability or sanctions under Florida law.
But it didn't say processing or cultivating or any of that.
Well, you have to take the words that are defined in that very first section and analyze those. Again, you have to look at every word in the constitutional amendment and give it meaning. The definition of medical use means the acquisition, possession, use, delivery, transfer, or administration of an amount of marijuana not in conflict with the department rules. And again, the department rules are dictated by...
So we have use, but where's the processing and cultivation by individuals?
The processing and cultivation would be presumed in the ability of the medical marijuana treatment center, as we approved with the request for judicial notice, that the medical marijuana treatment centers want to be able to give my client a growing plant. But again, you can't take an undefined component, the cultivate term, take that out and focus only on that and render nugatory or ineffective the rights given to a qualified patient. And again, all of these extraneous sources of interpretation, I would respectfully submit that you don't even get there because the plain language gives that qualifying patient the right to possess a growing plant.
What significance would you have us give, if any, to the frequently asked questions document, whatever it was, that was available to the public, which seemed to make clear that grow your own was not part of this amendment?
I would say that that's completely irrelevant and extraneous because, as all of the cases say, you begin with the plain language of the amendment. Not part of this record, but they've retreated from that. They retreated on January 8th when they argued the smoking case right here.
Well, let me ask you this. I mean, if we find an ambiguity in here, and it would seem that arguably an ambiguity could be the definition of marijuana says growing plant, but the only place it talks about cultivating is in the treatment centers. If we find that creates some sort of ambiguity in the constitutional language, could we then look to the frequently asked questions to get a sense of what was meant here?
The cases say you shouldn't because that would be referring to some extraneous source to deviate from the plain language of the amendment. The amendment says what it says, and again, I can't stress enough, you can read those different, the entitlements, the immunities, you can read those in harmony. A qualifying patient can possess a growing plant. If the department wanted to adopt a regulation like Maine that said you could have 6 plants and did it and it was in conformity with this section, they absolutely could do that. Again, I guess the old saying is equity does not reward the indolent. They've done nothing. They haven't set any amounts. They haven't set any of these issues. The only thing they've done is try to focus on one portion of this amendment to render nugatory other portions of the amendment that are so specific they leave no ambiguity. They're clear, they're unambiguous, and they're entitled to support. And all of the constitutional construction cases say you can't pick and choose. Even if it's something that's it's inconvenient or difficult or renders a hardship or any of the things that I think have been the gist of what we've talked about security and things like that, even if those things are difficult, which I would certainly submit would be less difficult if the department was to embrace their duties and adopt the right regulations that doesn't limit the forms of marijuana but recognizes what the rights are of the qualifying patient.
What significance should we give, if any, to the litany of items both in the medical marijuana treatment center definition, acquires, cultivates, possesses, processes, transfers, transports, sells, and then there's a similar but not inclusive list in medical use: acquisition, possession, use, delivery, transfer, administration. You know, it seems to me the 2 words that are missing from the medical use definition are the ones that are most critical to what your client wants to do with the marijuana: cultivate it and process it. But what significance should we give to the different language in those 2 sections?
Those are implicit in the right to possess a growing plant. You can't get there without implicitly understanding. And I think that's another rule of constitutional construction. If you're given a specific right, it doesn't exist in a vacuum. It gives you that right. You have a pathway to get there.
So your argument, a right to possess a growing plant includes the right to cultivate that plant and then process it?
Again, the definition of cultivation is not incorporated. And what I would certainly say to that is—
Where would we look to get that definition then? I mean, we would look to a dictionary, wouldn't we? To see
if you did, and again, I'm going to, this is for personal use. Cultivation certainly suggests that you're doing something on a larger scale. That certainly is contemplated in the definition of medical marijuana treatment center. And again, you don't want any portion of this amendment to be found to be absurd or ineffective. The use of the word transport. A medical marijuana treatment center is the only entity that can transport marijuana. But again, a qualifying patient, to apply that strictly, would be stuck in the lobby of the medical marijuana treatment center and would never be able to take his marijuana home. Doesn't allow, the medical use doesn't include transport, but that's implicit in the understanding of the fundamental right.
Doesn't it include transfer? The qualifying patient can transfer the marijuana.
It doesn't say he can. Only the medical marijuana treatment center
No,
can
B6
transport.
says it.
It does say it,
Medical
I
use,
think.
possession, use,
Right.
delivery,
Treatment
transfer.
center.
I'm talking about the medical use. It says
Right.
that the qualifying patient can transfer it.
So if you look at the medical marijuana treatment center,
Yes?
means any entity, et cetera,
Right.
Transfers, transports, sells, distributes.
And so medical marijuana treatment centers and qualifying patients can both transfer.
I'm saying that yes, they can, even though a qualifying patient doesn't explicitly have that right. It has to be construed in a reasonable fashion to give effect to every word in the amendment.
So go back to if we were to find an ambiguity. You said that you thought it would not be appropriate for us to look at the frequently asked questions website. Where would it be appropriate for us to look other than possibly the ballot summary as to what the voters intended for the legislation to mean, the amendment to mean?
I think that if you look at the plain language,
But
as
if
the
we
trial court-
look at
okay,
that and we decide it's
assuming
ambiguous.
hypothetically, then I think the last place you look would be a frequently asked question.
Where would be the first place we'd look?
The first place I would look would be the general definitions. What does it mean to cultivate? What does it mean to possess a growing plant? How can I reconcile those and still observe the sanctity and the effectiveness of every word of this amendment? I think all we're asking this court to do is to observe that it says what it says, but it also means what it says. And if the department was to absolve themselves of the inactivity that has been the status quo for the last 2 years and simply address these, instead of limiting or rendering nugatory those portions of the amendment, understanding that they're obligated to give force and effect to every word of this amendment and adopt the regulations that I think would facilitate that, then this would be a completely different scenario. But as we stand here today, I'm going to suggest that the plain language of this amendment is unambiguous and should be construed according to the terms thereof. Every term should be given effect, and the only way to do that is to affirm the trial court.
All right. Thank you, counsel.
Thank you for the privilege.
Two quick points in rebuttal. In response to Judge Weatherall's last question to Mr. LaRoe, I think the answer to that question is that they are arguing for you not to give any significance to the difference in those two lists of activities that are given this immunity. They're saying that anybody has the right to possess, has the right to cultivate and process, or has immunity to cultivate and process. They're saying everybody can do that, and I guess that would also apply to the physicians and the caregivers, because they have a right to possess for the purpose of what they're doing. So that's not the proper reading of the law. The other thing is the argument that they're making that we're just reading one part, or we're trying to read out of this a part. No, our argument is that you should read all parts of this. And it was Judge Gevers in a 22-page order that went to B5 and looked at the medical use definition and went to the qualifying patient definition, and never once in the 22-page order did she address the MMTC definition. She didn't even cite it or refer to it a single time. And if your one job in this case is to look at a new constitutional amendment and determine who has the state law immunity for cultivating and processing, and in a 22-page order you never even mention the MMTC provision that says exactly who does expressly have that ability, you've blown it at that point. So we ask that you reverse the decision from the lower court. Thank you.
All right, thank you, counsel. All right, our final case today will be Bowie versus Bluebird Landing Owners Association.